Tātou katoa. Well, a big welcome back to those of you who've been with us all afternoon, and welcome to those of you who've just joined us. For those of you who don't know, I'm Claudia Geiringer. I'm Professor of Public Law at Victoria University of Wellington and a co-director of the New Zealand Centre for Public Law. And it's a very, very special pleasure for me to introduce our keynote lecture tonight. When we planned this lecture, we had hoped that it might be able to serve not just as the keynote for today's event, but also as the launch for Dr. Dean Knight's new monograph, Vigilance and Restraint in the Common Law of Judicial Review, which is on the verge of release by Cambridge University Press. Unfortunately, the vagaries of publishing being what they are, we're having the party today without the party guest. Dean insists the book is locked and loaded, but we don't have the physical copies with us, and all we can manage is the pretty picture of it on the screen behind me. Still, watch this space, as Vigilance and Restraint will soon be selling at all good booksellers near you, or failing that, online at Cambridge University Press. And I've actually read this book, or substantial portions of it, and I can tell you it's a humdinger. When we advise students who are thinking of embarking on doctoral research, we suggest that they try not to be overly ambitious. Just bite off a little piece of the puzzle, we say. Your own little plot of the garden to feed and water and grow. Well, I'm not sure whether Dean didn't get this advice or whether he disregarded it, because for Dean's doctoral research, on which this book is based, he chose as his subject the entire metastructure of administrative law. The result is a work that is magisterial in scope, that transcends time and place, and that comprehends the doctrinal, the conceptual and the normative. This is not a garden, this is a rainforest. Perhaps we should not be surprised, as this is a scholar at the apex of his career who is now widely recognised as one of the leading New Zealand voices on a range of public law topics, not least administrative law. He's also a wonderful colleague who is beloved by students, both for his creativity in the classroom and for his commitment to their welfare. And so it is with great pleasure that I hand over the podium to Dr. Dean Knight to introduce us on to the subject of vigilance and restraint in the common law.
Kia ora koutou, talo whalawa, good evening, and thank you, Claudia, for those very kind words. And thanks to folk for your stamina, for sticking, for those of us that have been with us at our hui today, reflecting on matters that occurred in 2017. Thanks for staying on for something that is squarely more normative and perhaps a little bit more provocative. And thanks also for those people that have joined us just for this lecture. So, vigilance and restraint in the common law of judicial review. The interaction between these two concepts is just a way of expressing, I think, the phenomenon of the modulation of the depth of scrutiny. Something that I argue is one of the key features of the supervisory jurisdiction, and something that is deserving of deeper exploration and study. But before launching into that inquiry, I want to pause and express some nervousness about doing so, especially doing so in my home jurisdiction, oddly, because it's clear that ideas of depth of scrutiny and variability come with a lot of baggage. Reflect briefly on some of the judicial views expressed about a few of the most prominent circumstantial doctrine. And you've heard this first one already today, but deference, a dreadful word. Jurisdictional error, a chimerial distinction, a vague and probably undefinable concept. Anxious scrutiny, a catchphrase devoid of legal meaning. the innominate instinctual ground, a circular, indeterminate, and largely discretionary ground. Variegated standards of reasonableness, confounding tests and new words for old problems. Substantive grounds of review, surrounded in fog of the pea super kind. And I could go on and on. We can see that there's a lot of animus towards some key manifestations of variability. And I'd probably go further and say there continues to be fundamental disagreement amongst our courts about how variability in judicial review should be manifest. Even if I think there's acceptance that judicial review is a flexible jurisdiction and variability within it is ubiquitous. So my approach has been to adopt the broader conception of variability, in part, as Claudia said, by focusing on the meta-structure of judicial review, if we can call it that. I should have listened to that memo. That is, looking at the broad style of judicial reasoning and the shape of the supervisory jurisdiction as a whole. And it's for this that I find the language of vigilance and restraint and how the courts mediate the inevitable tension between those two impulses. I find that a more useful way to frame the study. And I've borrowed those terms from leading British Silk Michael Fordham. But really, it's just another way of expressing the idea that a dynamic operates in judicial review cases due to both primary issues and second-order issues being engaged. On the one hand, the goal of ensuring administrative propriety or individual justice and protecting the rights and interests of citizens, if you like, the rule of law. On the other hand, we have concerns about the legitimacy of the courts to definitively adjudicate on such matters. In other words, the judicial process may be ill-suited for the determination of the primary issues raised. For example, the relative expertise or knowledge of the administration may be superior. The judicial processes may not adequately accommodate the breadth of the issues raised. Or it may be more legitimate for the questions to be settled through more democratic processes. Perhaps, too, there may be concern about the necessity of judicial intervention generally. If there are other processes which adequately provide for accountability, legal or otherwise, then there may be less imperative a need for intervention by way of judicial review. Again, judges are not the sole or even the most sacred means of addressing grievances or promoting good governance. They work as part of a team. Now, I don't think that tension between vigilance and restraint or the drivers of it are controversial, nor the fact that they generate that inherent variability in judicial review. The controversy is about the manner in which the variability is expressed, if you like, the how question. So what I want to do tonight is share a couple of aspects of my project and ideas in my book. First, I'll frame and explain the main approaches employed to modulate the depth of scrutiny within the Anglo-Commonwealth family of jurisdictions, if you like, the doctrinal dimension. And secondly, I want to introduce briefly a set of criteria we might use to evaluate the efficacy of the different approaches. So that's my normative dimension that I'll tease you with at the end. Because stepping back from it in a nutshell, I've distilled 4 key schemata, the different styles or approaches adopted by the courts to the modulation of depth of scrutiny. Conveniently, scope of review, grounds of review, intensity of review, and contextual review. Each schema approaches that modulation question with a distinct style, approach, or emphasis. Now, they're only sketches that are emblematic of a general approach. I'm not claiming they are rigid or self-contained. For example, we may see some hybrids in cases combining different styles or exceptional instances. But the value here in thinking in schematic terms is that it then allows us to reflect on the virtue of delivering variability doctrinally or otherwise. So it transcends the quagmire. And I think until those different styles are acknowledged, debate about particular doctrine is almost pointless. we need that shared language first. Now, before I take you through each schema, something about their pedigree. The language I'm using here is distinct, but again it's borrowed. And here I'm using the Smith's Distinguished Textbook on Judicial Review to frame the different schemata and to trace loose trends. And this is the original in 1958, which I'll start with. Because the Smith's Textbook on Judicial Review is helpful to this project for a number of reasons. Its focus is on the judicial review of administrative action, core administrative action. Its time frame's interesting. First published in 1958 and often pointed at as heralding the rise of administrative law, and now it's in its 7th edition, soon to be 8th, thankfully, after the book's going to be published. It's got a nice, strong comparative aspect. It's clearly anchored in English-style judicial review, but with some Anglo-Commonwealth comparative focus. But its style of exposition is magic. It's analytical, almost scientific in character, and, if you like, less nakedly normative than, say, a Craig on administrative law or even Wade. And why a textbook? Well, I think resorting to a textbook or textbook writers provides a holistic perspective that judges, as situated actors adjudicating in individual cases, simply cannot provide. So what I'm saying is the Smith's textbook provides a series of cues about the nature and style of the system of judicial review it explains. So over its 7 editions, the language and structure has changed over time from scope of review, grounds of review, to perhaps at least formatively in the latter editions, intensity of review, with hints in the final few editions at a form of contextual review. Now I'm arguing that this change isn't just linguistic, it speaks to the change in the underlying style of review, and I've also traced it through the primary sources as well. So when we're thinking over those 7 editions, we can track a move away from legal formalism and categorical approaches towards more open-textured and explicitly circumstantial approaches. So, 1958, the first edition. Some word clouds. I should probably explain what they are. There's something to distract you for the duration of this talk. No, these word clouds depict the frequency of words from key and analogous passages in Smith's text. In short, the bigger the word, the more frequently it's used. Now, these slides are only illustrative. They fit conveniently with the trends I'm tracking. I don't construct my claims based on them, but I think they help visualise those key changes. What's striking in the first edition was it was built around the language of scope of review, based on categorical distinctions and formalistic reasoning. It reflects the then old-school judicial review, or the classic model as Carol Harlow called it, a binary approach to depth of scrutiny. Something was either reviewable or not. It's like a light switch, on and off. And intervention was, or depended on, rigid categories of analysis. And you'll be familiar with them, and you'll see the language in the word cloud there. Jurisdictional versus non-jurisdictional. Law, fact, policy. Process and substance. Judicial, administrative, legislative, and so forth. These multifarious, often complexly drawn categories, and if you like, fastidious line drawing were the dominant features. Very technical, very formalistic, very rigid and circumspect. Usually, but not always, synonymous with judicial restraint. On its face, ostensibly inflexible. The variability was expressed indirectly, we might even say covertly, by the classification of the decision or function due to a category that determined whether it was capable of being reviewed or not. Now, in truth, and Smith says this himself, the categories were malleable and manipulatable, but there was this covert categorisation process which dominated, was the flavour of the day. Now, that format in the Smith text followed quite strongly in the 2nd to the 4th edition, 68, 73, 1980, even though the details changed and the way in which the categories were drawn were redrawn, often to expose more decisions to review. Thankfully, and I'm not going to cite cases from this style because this style is largely out of fashion nowadays, following the Reformation and systematisation of English-style judicial review in the mid-1980s, except in Australia, where there continues to be a deep commitment to this abstract formalism, marking it out as the odd sibling within the Anglo-Commonwealth. So we might step back and say this style is only of historical interest here. Yet curiously again, its poster child, if you like, Wednesbury unreasonableness, still survives. And we can still sometimes see recent instances of the formalistic approach and old-fashioned language creeping back in, especially when judges recite the old process, not merits mantra, or when old-fashioned doctrine like jurisdictional fact are rolled out. But that'll probably do for scope of review for now. I want to fast forward to 1995 and the 5th edition. Because in the 5th edition we see a significant restructuring around the text around simplified grounds of review. And that's following, of course, the landmark CCSU case in the 1980s and Lord Diplock's systematisation of the tripartite grounds. You know them: illegality, procedural impropriety, irrationality. And that's echoed here by Lord Cook and his simplified trio of grounds in New Zealand. And those grounds were adopted as the organisational structure, or chapter headings even, of the dismissed text, and that format largely is the predominant structure in later editions too. As many of us were brought up on the grounds of review framework, we tend to assume its preeminence. Certainly that was my position before I started the study, and we really reflect on its method and metastructure. But it's important to think about how modulation of depth of scrutiny operates within this framework. First and foremost, the core methodology is classification, much like scope of review. We've got 3 grounds implicitly manifesting different depths of scrutiny. The first 2, illegality, procedural impropriety, or legality and fairly, reflect law and process. That's where the vigilant approach operates. The last is deferential, merits, irrationality. So the identification of the applicable ground of review effectively dictates the depth of a review. But here, under the grounds of review, there's less rigid categories than scope of review, acknowledgement of overlap, and I think open acceptance that a claim might be reconceived under different grounds. Significantly, though, grounds of review still employs a latent or indirect approach to modulation. And this may be done in a number of ways. And folk will probably be aware that in judicial review cases, the battle is to convince judges to treat the concern as matters of legality or process, not of substance, in order to access that closer supervisory eye. Might be through promoting international obligations to questions of interpretation, not of discretion, under our principle of consistency, presumption of consistency. Or by treating statutory preconditions as having legal dimensions, and thus triggering effectively de novo review, rather than being factual or evaluative and only being subject to a reasonableness test. Last week's Chamberlain's decision, I think, shows the power of framing under different grounds. There, the original challenge to carer's pay was substantially based on substantive legitimate expectation arising from a policy, and that challenge failed in the High Court, as expected, because of the inevitably cautious and restrained review in the merit sphere. But in the Court of Appeal, the Court of Appeal intervened after it treated the case as turning on relevancy and errors of interpretation, errors which demand strict scrutiny under a illegality ground. We may also see the variation arising from evolution or reformulation. as alternative grounds manifesting different and usually more intensive scrutiny develop over time, emerge, or existing grounds are reformulated. And I'm not going to dwell on the developments or perhaps lack thereof in New Zealand, because you'll know them. Just perhaps one mention to tie back to Justice Palmer's recent industry in the space. As Eddie noted in our seminar, he's been working hard to reframe the reasonableness ground, and I think we'll see what comes of that. We can also see the modulation coming through the circumscription of the grounds, as I call it, based on issues of justiciability. So that may make the decision a complete no-go zone. So compare the Curtis case refusing to review the decision to disband the Skyhawks with the recent decision to review Cabinet's assessment of the compensation payable to Te Napora. Or I think more commonly nowadays is partial circumscription of the grounds. For example, the commercial dimension in Mercury Energy or lab test justified the narrowing of the suite of grounds to bad faith, corruption, fraud, or something analogous. And as you've heard earlier today, the Court of Appeal recently recommitted to this partial approach in the problem gambling case, even though the Supremes have shown no enthusiasm for this structured approach. A witness, as Madeline told us earlier, in relation to the Osborne case on prosecutorial discretion, this rejection of an elevated set of grounds review. So that, if you like, is the fifth edition in the grounds of review. The key point is that while the variability occurs, it operates implicitly within a field of identified grounds, symbolic or reflective of different depths of scrutiny. We come now to the sixth edition. An intensity of review. And it's striking that that language doesn't occur in any of the earlier editions. And that's actually what animated this mode of inquiry for me, because I was trying to trace where the ideas of intensity in terms of the language jargon came from. There was only a cameo mention of intensity in the fifth edition, more prominent in the sixth, with a separate section presented as a full continuum of intensities of depths of review, albeit under the rubric of substantive or unreasonableness review. And you'll see some of the language of that being expressed in this word cloud. And I think it's notable for its prominence in attempts to connect and harmonise the different variants, and also it being teamed with the other related words, difference and latitude. Again, hunt them out in that little word cloud there. But still operating, if you like, within the shadow of grounds of review. So what's the method? Well, intensity of review invites judges to explicitly turn their mind to the depth of review in the first instance, either in terms of a position on a sliding scale of review, or by adopting standards of review with generalised depths of scrutiny. So what we've got there is conscious modulation of the depth of review. An explicit calibration process is the first stage of inquiry in supervision process. So it's direct, modulations brought to the foreground, based on the circumstances, not the classification of a function or error. And we know the factors that are typically relied on, things like legislative allocation of functions, institutional competence, especially the relative expertise of the courts compared to the administration, the functional suitability of the courts to adjudicate on those matters, the effect on the individual, particularly the gravity of the issues. So these are the drivers I was talking about before, the constitutional drivers of this variability and this tension brought to the foreground. And they're openly weighed or balanced in the mix when the court determines how to approach the case, how closely to scrutinise it. And that depth of review may vary with a range of different calibrations. So rather than the light switch of the off-and-on light switch of the scope and review, we've now got the dimmer switch, which has got a different range of intensities or depths of scrutiny. So the English developments have occurred largely in the human rights domains, either common law moves like anxious scrutiny when fundamental rights are impugned, Baghdadi case or the Smith a military case, and in some largely unsuccessful, I think, efforts to try and give the concept of deference in human rights adjudication some doctrinal form. We think about New Zealand, we can identify this schema or approach in the variegation of the unreasonableness ground. So that's the intermediate form of reasonableness review applied by Justice Wild and Wolfe, again, case mentioned earlier in the day, and in other efforts, largely in the High Court, to engage in the hard look in some cases. I think it's notable to see the Court of Appeal last year in Quake Outcast adopting this type of approach to unreasonableness when assessing the adequacy of the compensation for some red zone properties. More broadly, we can see the style and schematic form in Canada, where for years and years and years, a standard of review was explicitly selected as the first stage of the supervisory process, based on forms of correctness or reasonableness review. The different forms of unreasonableness were collapsed in the big Dunsmuir case 10 years ago, next month I think it is. Watch out for blog posts celebrating that development. But the foregrounding of the appropriate degree of judicial restraint or vigilance continues in the Canadian sphere even after Dunsmuir. So that's what I call intensity review and its essential method, where we see a reasoned elaboration by the judges about the selection of depths of scrutiny. Come now to the seventh. These books are getting more and more expensive to buy, so they get bigger and bigger. The contextual review, the final schema, must confess, prominent in Smith's text, apart from a few remarks emphasising contextual or open text review in a handful of short passages. But ideas of instinctive or discretionary review are also strongly being promoted by the likes of Philip Joseph here and Trevor Allen in Britain, and I think it's important to, I think we can bind those together to say, this is the direction of travel, perhaps. And we can think about contextual review in terms of abandoning doctrine, whether in the form of categories, grounds, or factors. Doctrine is replaced with a judicial instinct and a discretionary judgment, as it was put in the Guinness case in England, whether something has gone wrong that justifies the intervention of the court. We might see it and think of it in terms of doctrinal approaches that are so open-textured that their essence is an overall evaluative judgment. And we know here that Lord Cook's Simplicity Project had a vision of particular grounds that was so open-textured that they became all about a judge's overall evaluation and judgment. The more flexible approach in Guinness has been adopted and specifically relied on in a handful of New Zealand cases. Electoral Commission in Cameron is one notable one where that language of this more flexible approach was adopted instead of the traditional suite of grounds of review. And recently, Justice Ellis overturned the decision about compensation for Tēnā Pōra, concluding something in public law terms had gone wrong, close quotes, effectively adopting the argument, it was put in argument, that it was of no real moment to isolate any particular ground of review justifying intervention. Contrast that, if you like, with Justice Palmer again, in his recent rejection of the innominate ground of review a la Guinness on the grounds of its lawlessness and circularity in AI in brackets Somalia. We too can see some seeds of it in the Supreme Court, I think, in the Ruranui decision, where the majority was agnostic about whether the alleged error in the case was one of law or fact. It was sufficient, they said, or the majority said, that the exercise of public power was based on some material error. Certainly under grounds of review, whether the error was one of fact or law would have been instrumental and would through that sort of categorical approach. Think too of the current preference for non-doctrinal deference in human rights cases. Here I'm thinking of the Huang case in the UK Supreme Court, which is very much the leading case on this, where questions of restraint in human rights adjudication are simply bound up in the ordinary course of judging, where the views of others in the round may or may not be given weight and respect. And that approach to questions of deference and statutory appeals from specialist tribunals and courts can be seen here too, I think, under our Austin-Nichols principle in relation to appellate review. Finally, we can connect it with moves in Canada, as I said, post their big Dunsmuir case, to adopt what we might call a broad church circumstantial standard of a reasonableness, vast sort of church that it is, very broad, as part of their standards of review regime. I think that's also manifesting that style. So that's contextual review, and if you like, unstructured normativism, because that's what's going on there, is preferred over doctrinal reasoning. And it's no surprise our Chief Justice is a fan of this Cookean approach, or this contextual approach. Certainly, when she was abroad recently, she was promoting our, as she put it, simpler path of optimistic contextualism, downplaying the role of doctrine in judicial review and asking rhetorically whether, as she put it, the search for better doctrine is ultimately doomed, ? Some might hope not. So that's the sort of the four schemata, and the aim of my book, one of the aims has been to try and evaluate the efficacy of these four different judicial approaches, and essentially to identify the different trade-offs each judicial style involves. And the time I've got left, and I want to leave some time for questions at the end, I want to give you some flavour of that normative dimension. And here I'm suggesting Fuller's principles of legality, his rule of law-based criteria, might help us in that task. And you'll probably, well, if you can remember back to that rule of law class in public law, my students certainly have forgotten it, you'll be familiar with the basic ideas that underline that sort of rule of law, those rule of law criteria. Generality, public accessibility, prospectivity, and so forth. And I've added one, hortatory versatility, which I'll come back to, which looks at the scheme as educative role. I'll explain those in a little bit more shortly. But I want to justify the approach I'm taking here. Because I think the adoption of these lines of inquiry is an attempt to take I hope it's an attempt to take our debates beyond simple assertion that some approach is too complicated or might be more robust than others. I think we can expect better than that. Because if we treat the schemata that I've described as rule regimes which regulate the exercise of power and discretion of judges in the supervisory jurisdiction, then Fuller's rule of law-based criteria makes sense. Judicial review of administrative action is not merely the judicial supervision of the exercise of power by the administration, but it's also the creation and deployment of rules about the exercise of judicial power. Judges are agents of public power too. Thus, it's my argument that Fuller's rule of law criteria then provide us with a rich way of assessing the different schemata. Now, the concerns of each are generally self-evident, as I say, and in my book I explore how some of the particular criteria speak to that question of judge-created schemata around modulation and depth of scrutiny. So just a little taste to close. We think about ideas of generality and prospectivity. These principles value the explicit articulation of the judicial methodology in advance, something the grounds and intensity of review schemata do quite well. But the contextual schema does poorly because of its woolly character. So too does the principle of public accessibility. The transparency that comes from explicit categories, either under scope or grounds of review, is acknowledged to be valuable. Or the explicit reasoning associated with the selection of the depth of scrutiny under the intensity of review schema, where relevant matters, those constitutional drivers, are brought to the foreground. But public accessibility is sceptical, or the principle is sceptical, about too much judicial discretion. Instinct or overall evaluation in the round risks losing transparency as it gets hidden in the hunches of judicial figures. The clarity principle objects to the doctrinal quagmire of the old-fashioned scope of review approach, thankfully, but is also critical of the vagueness associated with contextual review. Not impossibility, that principle can be seen as raising questions about whether these approaches are practical. Practicality or lack thereof. And that's a complaint that's sometimes levelled at the intensity of review schema, especially if court time is disproportionately devoted to settling preliminary questions of intensity without any forensic certainty needed for preparing argumented evidence and so forth. But contextual review is also a nightmare for litigants, with little, if anything, to ameliorate that open-textured nature of supervision. No scaffolding. Never sure if one will face an interventionist judge or a more cautious one. Stability really doesn't raise any big issues here, although those schemata that are heavy in judicial discretion, like contextual review, might cause some awkward shifting of the sands. Congruence is an important one, I think. Congruence expects that the controlling methodology actually be applied in practice. Something that scope of review schema is criticised for was well criticised for not delivering on, as complex categories are manipulated. The final one, and I'm adding this to Fuller, the hortatory versatility, looks at the collateral role of judicial review in expressing administrative law norms, the principles of good administration that might guide the executive in their day-to-day work and encourage ideas of good governance. That's important to judicial review too, I think. And the grounds of review schema, when expressed in positive terms like Lord Cook, acting in accordance with law reasonably and fairly, is a useful educative resource. Judge over your shoulder is built around that framework as grounds of review. But if we contrast that with intensity review and contextual review, these approaches provide little guidance to administrators about the values of the administrative system or how they should make decisions. So that's a little bit of flavour of the lines of analysis, and that's probably sufficient for now. But you get a sense of the nature of the normative analysis. Now I want to pause and anticipate a question or concern and note that the variability inherent in each of the schema mean the delivery of administrative justice, I think, can be assumed. They all allow judges to intervene to address error. And that allows us to hone in on the how question, how they do so. And I think that the fact that the supervisory jurisdiction is in itself a check or review function does not prevent the scrutiny of its internal morality and how it explicates methodological rules. Now, it's not my aim here to herald a new ideal type or winner. There'll be no Oscars or prizes about which one wins. In many respects, I think what my book suggests and my work suggests is that the devil's in the detail. The trade-offs are trade-offs, and we need to decide what are the trade-offs that are more important to us. And of course, I've got to leave some mystery, so you'll buy the damn book. But I guess ultimately, through this project, my aim is to shift the conversations to those trade-offs rather than being about our obsession with their language or jargon. So hopefully isolating some of those distinctive elements of The superstructure of judicial review allows us to have richer and more meaningful conversations about those important matters. Thank you.
Well, I told you it was a humdinger. Dean says he will take questions if anyone dares.
Dean, that was really very interesting. I just want to ask one simple question about whether there are some American materials that may be relevant to this. The first one would be Chief Justice Stone's famous footnote in Caroline Products in the mid-1940s, footnote 4, where he talked about discrete and insular minorities, and that would produce much more intense constitutional review. And then there is the famous American case on Chevron, where they talk a lot about deference. I haven't read that lately, but it's celebrated in the United States, and I wonder if that casts some illumination on this question of variability.
Thanks, Jeffrey. Yeah, I thought about that, and I heeded the memo about not going too large, partly because adding, it made some sense to stay with the consortium of English-style judicial review, and I justify that on the basis that, one, in many respects, that Canadian approach has adopted and absorbed some of those important developments in the US, where deference, Chevron, and the likes have also been well ventilated, and the constitutional more intensive scrutiny. You could translate some of the broad schematic approaches and say, yeah, it's almost an intensity review approach because it's bringing those things to the foreground. The other thing is there's also another guy who was first out of the blocks on that. Paul Daly wrote a book on deference and ministerial rule where he used the US as one of his comparators. So I stayed away from that, but I think I'm coming, and that's why I've come in with the Smith to sort of anchor in that English style, but I'm mindful of those developments in the US, and I think we could connect them informally if we need to.
I actually have a question while the rest of you get going, and but I'll ask mine anyway. So you talked about Cookean-style contextual review. You talked about Cookean-style contextual review, and I guess Cook was responding really to the jurisdictional approach that your first approach, which I think you call the scope of review approach. So my question is, do you think that Cook would be a fan of modern day contextual review? Elias style, perhaps?
It's a really good question. And Cook was incredibly savvy with doctrine. And he did come from a different time. And one thing I've been careful in the book to try and do is to not make large normative claims about an ideal type. Because in many respects, we can only consider those trade-offs in particular time and space and on the backdrop of a particular trajectory of common law development. So I'm not, that formalism still exists in Australia. I'm not going to say in Australia, it's scope of review's mad. You need to move to this modern sort of Canadian thing. That might be, there may be other ways, and the trade-offs may sound differently in a jurisdiction which is at that stage of development. Same, and Cook was working against the back of scope of review, and his innovations was magic. Because that was a nightmare, and I've gone through those 4 editions of De Smith, and it made my eyes, glaze over every time I went into it. And so he's operating when that's it's contemporary, when it went off the back of that. What would he think today when I think we've probably got a grounds of review framework with ideas of intensity and a prodding in the Supreme Court, and Philip Joseph suggesting we need to move to this sort of open textured approach? I think he'd probably favour a little bit more transparency in the conceptual reasoning. I don't think he thought it all came down just to a hunch. I think he was more savvy and sophisticated than that. But I don't know. Welcome other thoughts on that. Kia ora.
You sort of, given what you've said about the manipulability of doctrine, have you sort of tried to track the extent to which the different models is just a difference in candour, or is it, or do you think there are actually different levels of constraint on judicial activity under the different models?
Oh, and thanks, that's an excellent point. When I sort of concluded and said I think you can still do the work and achieve administrative justice under any model, the models, I mean, you've got to do a lot more work under a scope of review, sort of abstract formalism, doctrinally heavy approach of the old 1950s in Australia nowadays. There's a lot more work and gymnastics, if you like, to sort of reach the result, the desired result, or get the right flavour of balance between restraint and vigilance. Obviously, if you're under contextual review, you can do whatever you want. Well, that's what it says. It's overall evaluation. You consider it around. There's less constraining there. So I guess what's going on in there is that as we move from scope of review and grounds review, which are categorical and indirect and latent, you've got to work within those categories, and it's a different language or voice. And I think it can be criticised for a lack of candour, and that's something I draw out as one of the trade-offs. Once you get an intensity of review and contextual review, you can be candid, and those different circumstantial approaches require different explanations in language. Intensity review requires you to do some work and to articulate those sort of constitutional conceptual drivers and how they play out. Contextual review doesn't. Oh.
I wonder how the different schemata overlap. Specifically, the second one, so the general theme of the book and the presentation is the how of the question. But the grounds of review only incidentally after the how. They're actually the why. So do you think you can start with the baseline of why, whether it's jurisdictional or grounds of review, and then the intensity of the contextual review has something to say about the how?
Yeah, thank you. And in many respects, the schemata, I'm going to say, I don't want to use exaggerated because that overstates it, but are emblematic of a general style. This is one, New Zealand grounds of review, predominantly Canada intensity review, but we actually know in truth there's some intersection of that sort of stuff going on. I think that what it's useful to do is when we're thinking about those, to divide those two questions. And Tom Hickman does this magically, where he talks about the difference between standards of legality or grounds of review and standards of review, the intensity question. So one's talking about the standards applicable to the administration, what the goal, what the benchmarks are, as opposed to standards of review or the intensity question, which is about what the judges do in their work. I mean, what I left open in the book is how those two might merge and interact. But for analytical purposes, I think it was useful to keep them separate so we can draw out their different virtues. Well, I take seriously the concern about the predictability, but also its tension with the flexibility needed to achieve justice in individual cases. So it's a tension and a trade-off. But I think current state of play, I think the emphasis in New Zealand, the direction of travel has been to judicial flexibility and stepping in whenever they see something that's wrong. There's a cost to that. Administrators don't know where they stand, litigators don't know where they stand, and we've got to take that seriously about whether that's a trade-off we want to bear. But that goes to, I think this has got to inform that curation of those methodological rules by the judges. How do you draw those balances? How do you get our rules of judicial review to do the work of both? Addressing wrongdoing, but also educating administrators, giving the confidence and the autonomy they need to be able to make decisions reasonably readily.
We've got two, but they're both troublemakers, so I
Oi.
Stephen Price and then Andrew Geddes in the middle of someone.
I stole the mic off Eddie. Thank you, that's very kind. Looking very big picture at your project, do you see the shift that's occurring within the realm of judicial review that you describe as being sui generis, something that's particular to the practice of judicial review and driven by, if you like, judicial review specific issues? Or is this part of a bigger shift in judging and the way law is perceived? In other words, is this something that's happening in the broader field of law, that these sort of changes to legal practice and legal reasoning are happening, and this is the specific instantiation of it with regards to judicial review? Have you thought about that at all?
I'm just not smart enough to answer that excellent question, I think, because I know a bit about judicial review. I'd love to know more about areas of private law and equity and things like that. In correlated conversations, I think there is something, especially in New Zealand, about the dominance of the public law method. So I think we can see the spillover of ideas about a model of judging that arises in judicial review into other areas as well. And other people in the room, my colleagues, will probably, hopefully, be saying, that's like, was it duty of care and tort, or equity, whakatū, things like that. Because in many respects, our senior courts are very much, I think they wear their public law values on their sleeve when they go into that beautiful Supreme Court there, and inevitably they draw on that for cognate areas. But I just haven't been, I can't prove that, but I think it's an excellent question. I am awful, which is why I did this project, because I am just a dog at trying to pick them. My students know this. I say, they'll never get home in that, Osborne, there's no chance, whatever. I don't know. I mean, but that's, again, it goes back to that point, is that I'm not going to obsess about certainty and predictability, but it's got some sort of place as well, balanced against, as I said, those ideas of flexibility. But in talking to counsel and other people that are actually litigating things, I know they feel this. How many of them, give me a call and say, got this judge, they probably shouldn't call me because I'm useless on it, but got this judge appearing before, what are they like? What are they, and if it turns on that, I just worry that it's an indictment of our legal system. I know, we all know the realist movement and, judges' values are influenced, but should they be so heavily in the influence that their hunches or that sort of intensity preference dictates the outcomes of cases? I'm not so sure. I think there's, potentially, as I say, rule of law concerns that arise from that.
Well, on that low note, thanks, Stephen. Well, I want to start by thanking Dean for this extremely interesting and insightful glimpse into his upcoming monograph. It's been a real treat and an intellectual high point to a long and, I hope, stimulating day or afternoon. It's my job to close the conference, and I want to start by saying a huge thank you to our administrator, Rihanna Maxwell, who is brandishing a camera in the middle row, who's just done an absolutely terrific job of arranging this event. And she's also had today a wonderful team of volunteer students. So thanks to all of you. We've really appreciated your contribution. To all the presenters, and especially those who've come from outside the institution, our friends, as I think we called them, we really appreciate it, and it's been a terrific afternoon. And most of all, I'd like to thank the audience. Thank you for coming. We really are very interested in your feedback. Would you like to, for us to have a repeat performance next year? And if so, what would you like to see the same or different? So thank you very much. It's been a long afternoon, but for me at least a very enjoyable one. And I wish you all a pleasant evening.